Yeah, hi friends, it's Harpreet Singh from Western Law Firm. So today I want to continue with the small claims series, where in previous video we discussed about small claims, how to file it, which are the typical cases which goes to small claims court, and what's the basic process of filing a claim with small claims. So today I want to discuss about, like, before trial, what the different things which usually people does for different kind of situation which come across before the trial. So the first important thing you have to make sure, especially when you are defendant, because when you are plaintiff you have already filed your claim based on whatever you think the best court is to adjudicate this claim. But for defendant you need to make sure, because plaintiff obviously have to serve the defendant with these documents, especially that's SC 100 form, and so the defendant has to make sure the defendant is sued in proper court. Is that right court or not for this kind of claim? Because in SC 100 form, because it's a very brief form, it's not your typical civil complaint extensive one, because of its reason it's small claims. So the defendant has to make sure that whatever the claim presented by the plaintiff, and obviously plaintiff will not list out causes of action in them because small claims is not structured in such a way. So usually it's breach of contract or some tort claims. So if there is some story or description, and probably if you are defendant you probably know about this dispute already, so you have to make sure that this is a proper court to deal with this issue. And mostly if it's filed in the same county where you are living, then it's obviously a proper court. But most of the time, sometime people plaintiff file a claim, especially in an employment law case, they file a claim in their own county where they are living, based on, if suppose you have a dispute about is this employee an independent contractor or a normal employee. So the employer has to just bear this burden to defend this claim in some other jurisdiction or county where he is not supposed to be in that county, because all the other, I think, activities of this employment happen in a different county. The performance was supposed to happen in different county, payments happen in different county. So here in that situation the defendant have a good argument to make that this is not the right court and this claim should be dismissed and plaintiff should file their claim in a proper court based on our situation. So usually in breach of contract cases, either wherever the contract is created or the performance of the contract was due in a particular location, or if suppose the payment was supposed to be made in a particular county, then you can make a particular argument that this claim is not filed in a proper court. So how you can make that, I think, request to the court? The small claims doesn't have a specific form. Usually small claims court have forms for a whole lot of different kind of things. But for any kind of motion, because usually in a normal civil case you just file a motion to change of venue of the trial, but in this situation the small claims court doesn't provided you any specific form, but there is like a general form which is SC 105, which is a request to the court for an order before trial. So this is kind of a form which you can use for any kind of motion or any kind of, I think, ruling you need before your trial. So it's a very simple basic form. Basically you just mention all your issues and request the court that this is not the proper court. It's obviously good to have an attachment sheet so that you can explain all the issues, and if you also want to include any statutes to support your argument, That's always good. Then once you file this request with the court will have a hearing, and obviously if it's filed and if the trial is upcoming, usually the court will postpone the trial, because the court want to first make sure there is a jurisdiction, the personal jurisdiction for this court to handle this matter, because jurisdiction is really very important, because jurisdiction is that kind of an issue where if jurisdiction is not proper and court provides a judgment, even at a later point, the defendant can challenge that judgment just based on jurisdiction, and if it's not proper, then obviously that judgment is not effective. So courts also want to make sure that they have jurisdiction based on the issue or the dispute. So the judge will provide another date to you and have a hearing on this particular topic of venue, and if the judge looks after the hearing that venue is proper based either on your contract or in a tort situation like car accident where the accident happened in some other county where the claim is not filed or where you don't even live. So the judge will make sure all those facts and listen to all the arguments from both sides. So this is one of the way, SC 105, but also in small claims you can always write a letter to the court clerk to just request a change of venue and ask for dismissal of this claim based on that it's not filed in proper court. So the next, I think the activity which usually can happen before trial, amendments. Because amendments, as you know, means when especially you're not in a legal profession, you think about certain things at a particular point and then you find something later on after filing your claim, or you think about something after again reviewing your filed claim that this needs to be modified. Suppose it's a damage amount, or sometime you sued some third defendant and now you want to remove that defendant, or you want to change the name of that defendant because later you just knew that this defendant is an LLC, not a corporation, but you have mentioned it as a corporation. So the important thing is that you need to do an amendment with the court clerk. So there is a specific form for the amendments. It's SC 114. Or either you can do informally through a letter to the court clerk indicating that, okay, this is the thing I want to amend in my claim. Maybe by mistake I have just mentioned an incorrect name of defendant or of plaintiff itself, or there was some incorrect amount or some thing you want to strike out. You can always do that at last at your hearing, but it's always good to do that before, because why to just waste people's time when you are just at hearing and then you are just coming up with this issue. But still, it's small claims because there is no formal process of like discovery, and you can come across different thing. And if you amend your complaint, it's good for the judge so that he or she can, I think, look at before even I think you are in this trial hearing for your case. So, and also it's really very important in whatever request you are making to the court, either through the amendment or change of venue, you always serve all those documents to defendant, because it's really important what you are communicating with the court and what kind of request. Always defendant should get a copy of such filings or such letters. So the next, if you want to dismiss some defendant, then what you do, because dismissal may happen because once you serve to the defendant your complaint, defendant may engage with you in a negotiation, and later if you just come to some kind of settlement agreement, then once your settlement is complete, you need to make sure that you file a dismissal because that's required as per your settlement agreement, and it doesn't waste court's time, because court is providing you time for this trial, and it doesn't, I think, backlog all the other cases just because you just forget to dismiss your case, and this case comes for a trial and no one is there. Obviously, if no one is there, judge will just dismiss that case, but still it's good to file a dismissal once you have settled your case and you got what you want. Or sometime, I think, you just think you have just included like 2 defendants and you want to just remove out 1 defendant, maybe because of some personal situations, or you had some talk, or maybe some future business connections you are thinking about. So you can always, I think, dismiss either parties. If suppose one plaintiff want to dismiss themselves, they can do that. So for the dismissal, you have to make sure like either you're dismissing with prejudice, without prejudice. So these are the legal terms. With prejudice, when you are dismissing the case, that means that you don't have any right to file it again. So you are dismissing with prejudice. Prejudice means that you are getting some right out of your way, and you will not able to exercise that right at a later point. So if suppose you think about that, okay, I don't want to deal with this defendant now, or you don't have evidence at this point. You thought you once filed the claim, probably you would supposed to receive something within 15 days or before trial, and you don't have it. There is another mechanism, but still, if you are thinking about a dismissal, you can always dismiss without prejudice, so that later you can again file it, so you are not waiving that right to file your claim again. Or you can, if your case is resolved, you settle, you got all the amounts which you need, and now you just want to move on, you can file with dismissal with prejudice, so you don't have any right to file. And obviously a defendant will need that dismissal with prejudice as part of the settlement agreement. So the next thing and the next tool which defendants or plaintiffs can use, it's the postponement or the continuance of your trial hearing. Because things come up in life, you have a trial like after, it depends on county a lot, because some county schedule dates for like after 3 months of your filing of your claim, and some counties schedule it for like after 45 days. So it totally depends on your county, and you have to ask the court clerk, what is the possible date I can get. If suppose you got a date, you just come up with some kind of other personal work, or it seems that you don't have I think at this point adequate evidence, you can always request court, and your request needs to be supplied by good reason, that this is particular reason, either you're sick or defendant is asking for more time to make payments, or to provide you some documentation. Because as there is no formal discovery process, if suppose you ask defendant for some documentation, and if the trial date is just 15 days after your request, so you most probably would need to ask for a continuance of the trial hearing. Defendants usually ask that because defendants are not the person who are choosing these dates. They are just served with this claim, and now they have to just appear on this particular date in front of a judge. So defendant doesn't have any control on this date. So obviously defendant, if they have some kind of work, then they will request a postponement of the trial hearing based on either its medical reasons or some other personal reasons, or just to communicate more and to come up with some kind of settlement. So obviously the court will always like that things resolve before a trial. So the court will provide liberally the postponement of this trial hearing. So with this postponement, you can always, there is, as for small claims, there is always forms. So the form for this one is SC 150, or you can always use letter with small claims. You just send it to the court clerk of small claims and you just mention your request, your reason, this is the reason, and court usually grants any postponements, unless and until you have been asking postponements from like last 2-3 times. So but usually postponements are granted in spirit of maybe parties are dealing with each other and they just want to resolve their case. So these were different activities which happens before your trial date, and also for defendants, you just prepare your case. If you don't want any postponement, you're ready, you're not getting any dismissal from the plaintiff, you just get ready for your case. And in the next video we'll talk about how to get ready for your case, for your trial hearing, and what can happen at the trial hearing and how it's structured. So in the next video, see the next video for the series, and we can talk about more information about what happens at the hearing. And in the later videos we can talk about, once the hearing happen, someone has lost, someone has won, what people have, what kind of rights after that. So it would be really very interesting to see, especially for plaintiffs. So see you in the next video, and thanks for again watching these videos. Thank you.